Hi, my name is Sydney Floyd, and as you may know, I'm the attorney for your company, S&W Seed. You're receiving this video message in regards to the alfalfa production services contract that has been negotiated between your company and Pioneer Hybrid International, Inc. Upon your signature of this agreement, these terms will become legally enforceable against both your company and Pioneer. Therefore, I want to take just a few minutes to walk you through the terms of this agreement, highlight the particular areas of importance relating to your company's role, and provide clarity to any areas where questions might possibly arise. I've attached a full copy of the contract as it currently stands to this message so that you can follow along and make note of any additional questions or concerns that might arise during our discussion of this negotiated agreement. To start, I just want to refresh you on some important background information that is relevant to this agreement and its terms. In the recital section, immediately following the introductory paragraph, you will see that just 12 days prior to the negotiation of this contract, your company and Pioneer entered into a separate asset purchase and sale agreement referred to in this contract as the APSA. Under the terms of the APSA, your company was able to acquire the field production capacities and seed conditioning and warehousing facilities needed to carry out its duties and obligations that have been negotiated for under this agreement. Now, I just want to walk you through some of the defined terms in this contract that are of particular importance. If at any point capitalized terms are used in the text of this agreement that are not otherwise defined in another section, they are to take on the meaning given to them in the APSA. Therefore, I advise you to make note of any undefined terms that you see and reference a finalized copy of the APSA in your company's records to confirm your full understanding. A definition in the recitals that also warrants your attention is the term production services, which provides an overview of the services that Pioneer wishes your company to provide for them, which consist of field services, conditioning services, bagging and treating services, quality control services, handling services, and stewardship services, all of which are, of course, subject to the specific terms and conditions that are later expressed in this agreement. If you turn to Section 1 of the definition section, you will see a list of defined terms and their locations. The term contracted amount found in subsection 1N means the number of units of alfalfa varieties and purchase units that are to be produced by or receive the benefit of services provided by your company. For each of the 3 years that this agreement is intended to remain in effect, 2015, 16, and 17, Section 2B, Roman numerals I, I2, and I3, define how each year's contracted for amount is to be calculated. Section 1H defines the bagging and treating services to mean your company will provide packaging in bags or pro boxes, tagging, labeling, treating with fungicides and inoculants, and palletizing and plastic wrapping for the alfalfa varieties in any purchase units under this agreement. Section 1L defines the conditioning services to be provided by your company to mean cleaning, sampling, handling, and testing of all alfalfa varieties. Section 1U defines field services to be provided by your company to mean all aspects of alfalfa variety production, including but not limited to locating and contracting for fields that meet appropriate Pioneer standards, providing field supervision of growers, providing and accounting for all parent alfalfa varieties, supervising all planting, including replanting, monitoring the growth of alfalfa, applying all appropriate pesticides, herbicides, fungicides, and fertilizers, properly managing the harvesting of alfalfa varieties, and inspecting the growers' planting and harvesting equipment to ensure that the equipment is clean and in good operating condition before its utilization in growing, harvesting, or handling of any of the alfalfa varieties under this agreement. Section 1Z defines handling services to mean the loading, unloading, inventory and tracking documentation, administration, lot tracking, insurance, and storage of alfalfa varieties. Next, I want to explain some of the risk, obligations, and liabilities relating to your company under the agreement. Under Section 3, relating to field services, your company is responsible for all costs associated with planting and replanting, and those involved in compensating growers, monitoring, fertilizing, spraying, controlling weeds, insects, and diseases, irrigating, insuring, harvesting, and transporting the Pioneer products under this agreement. Additionally, Section 3 also obligates your company to account for all parent alfalfa varieties that are provided by Pioneer and requires your company to facilitate return of all unused parent alfalfa varieties by growers to Pioneer no later than 15 days after that particular planting period is complete. Similarly, under Section 5, handling, rebagging, and return administration services, your company is obligated to provide and pay for storage of alfalfa varieties and purchase units that are subject to this agreement terms. This includes providing or contracting for storage space, management and security of the storage products, and insurance for the period in which your company provides such storage services. While these provisions might appear to place a large amount of performance risk on your company, this, as you know, is simply a standard practice involved in contracted for agricultural production services. So, it is unlikely that Pioneer would be interested in renegotiation of such terms. However, there are ways that we can potentially shift some of these risks and responsibilities onto subcontracted growers and service providers that are hired under other agreements by your company, which share part or all of the blame for why your company's obligations were not fulfilled under this agreement. There are a few other important matters that I want to bring to your attention before we close. Section 8 of this agreement, regulatory management, is of particular importance given the fact that it requires both you and Pioneer to obtain all regulatory approvals necessary for performance of your specific obligations under this agreement. Such regulations may include, but are not limited to, those imposed by the United States Department of Agriculture, the USDA, and its Animal Plant Health Inspection Service, APHIS. For example, your company's field service obligations include, among other things, the application of herbicides in order to prevent the devastating impact on yields caused by weed infestations. However, use of such herbicides are regulated and restricted according to results of environmental impact statements. So, I recommend that your company maintain continuous communications with the USDA concerning all of its obligations under this agreement to ensure that you remain up to date with all the applicable regulations and protect yourselves against inadvertent breaches that might be made under this agreement. It is also important to note that all disputes between your company and Pioneer arising out of or relating to this agreement are to be resolved in the following way. First, the designated senior management representatives of both parties are to promptly meet and attempt to resolve the claims, issues, or controversies at issue in good faith. If no resolution is reached by such representatives within 30 days after the dispute is referred to them, the dispute must then go to binding arbitration in accordance with the Center for Public Resources Rules for Non-Administered Arbitration of Business Disputes and according to the terms laid out in this agreement. To conclude, I want to make a few suggestions of possible changes for you to think over before our next meeting. In Section 2E, the agreement provides that your company may make a request to Pioneer asking for their consent to extend service terms relating to an IT transition services agreement made between the two of you at an earlier date. Upon this request being made, Pioneer, under this agreement, has the discretionary authority to withhold such consent for any or no reason at all. I suggest that this language be either isolated to the referenced IT Transition Services Agreement and removed from the contract altogether, or in the alternative, be rephrased to only allow Pioneer to not act unreasonably in withholding their consent to such issues, as this decision would certainly impact your company's ability to acquire information technology systems that would support your required obligations related to the production services under this agreement. Under the first paragraph of Section 3, your company is obligated to use commercially reasonable efforts to secure sufficient contracts for planting acres needed to meet the specified terms of this agreement. The language in this section goes on to state that your company will be responsible for a specified amount of damages if they have not planted or subcontracted out for the planting of such acres. The phrasing of this section is confusing in the fact that it appears to place liability for damages on your company's failure to successfully ensure that the requisite number of acres are planted, regardless of whether or not your company used commercially reasonable efforts when trying to fulfill this obligation. I suggest that this language be reworded to ensure that liability will only attach to your company if and only if your failure to use commercially reasonable efforts was the but-for cause of the planting acreage not being met. There are obviously other important sections of this contract that have not been specifically addressed in this video, so I advise you to look over it fully and contact me with any questions or concerns that you might have. Thank you.